Welcome back to another episode of Game Plan for Recovery. We are here with Jeremy and Chris today talking about private equity firms when they're facing out-of-court restructuring versus bankruptcy for one of their portfolio companies. So, Jeremy, first questions to you. With everything that's been going on with COVID, I'm sure some private equity companies are unfortunately having to look at winding down one of their portfolio companies. So, what are you hearing? What are you seeing out there?
Yeah, thanks, Michelle. I mean, it's definitely the case today. When you think back, at the time of these investments, and private equity firms look through the worst case scenario of these portfolio companies. No one's thought the worst case scenario would be, well, we shut down our business for 3 months. So it's had huge repercussions across just about every industry, and we're seeing a lot of private equity firms really looking at what they can do, looking at cash positions, the viability of these businesses. And when this first hit, the advice to a lot of the portfolio companies was draw down every amount of capital that you can. Draw down any facilities that you have available, start negotiating with the banks. And the private equity firms have been very active with their portfolio companies, managing a lot of the communications with the banks. And what we've seen is a lot of the private equity firms have worked with the portfolio companies. The ones that have been in cash vulnerable positions, they've worked and gotten some flexibility from the banks. They've bought some time, whether it's through the end of July, through the end of August, but we're coming up to that time frame where the banks are going to be much more aggressive and much less lenient than they were. So what we're seeing is a lot of the private equity firms are they've gone through the triage mode. They know which portfolio companies are doing just fine, ones that are going to make it but will struggle a little bit, and then the ones they have in a red category. And those are the ones that are really sitting down looking at now and trying to understand, okay, what is going to be the best option? Can we put more capital in to get this company over the hurdle? Do we need to look at potentially refinancing? Do we need to look at restructuring the debt and the rest of the capital structure and working with the lenders and other creditors that we have? Or do we have to go down the path of in court full restructuring? And the part of the problem is when you look at the choices between an out of court restructuring versus a bankruptcy filing, there's a huge reputational issue. So it affects both the portfolio company brand and reputation as well as the private equity firm brand and reputation. So they're doing everything they can to avoid those Chapter 11 filings and working with the banks and working with the creditors to try to find the right solutions.
Makes sense. Well, this feeds right over to the question for you, Chris. When compared to a bankruptcy, why would a PE firm consider doing that out-of-court process like Jeremy just mentioned for one of their portfolio companies? What are the benefits?
Yeah, no, Jeremy had some great points as to both pros and cons. I mean, there's several benefits too on an out-of-court restructuring. Probably one of the biggest factors that we consider is costs. An out-of-court restructuring can realize savings on professional fees and expenses, which for some companies may amount to millions of dollars. Even more prevalent is coming out of the recent, or I'll call it more recent, changes under the UST fee charges and guidelines. And basically under the UST guidelines, you're now charging additional administrative costs, which are going to be burdensome to certain large debtor type companies. So ones that have either multiple debtors or high disbursement volumes. And these now can go into the millions of dollars. Outside of the financial aspect, and outside of the cost argument, there's several practical benefits as well. And Jeremy mentioned those. Unless a company is publicly traded, negotiations are going to be kept private. So to your point, it's less damaging to the company's reputation. And then also, an out-of-court restructuring can address specific issues. So there's a benefit if you're only trying to address a few certain creditors or certain constituents. And then also time and concept of your management's time and that value. An in-court process leads to management having to go and deal with court hearings, with gathering information for court-appointed committees, et cetera. An out-of-court restructuring kind of avoids that. Now, while an out-of-court option is typically less expensive than a bankruptcy, they do come with certain costs and certain downsides. The downside of an out-of-court restructuring is that there's no automatic stay. Creditors can continue to enforce their rights. There's no automatic ability to assume or reject or reassign leases and contracts. and you don't have the proverbial hammer or the tool, if you will, to leverage creditor constituents who don't want to cooperate with you. I think going into it between the out-of-court and the in-court options, you also consider other options such as an Article 9 sale or an assignment for benefit of creditors. And more recently, under the CARES Act, you can look into Chapter 5 type bankruptcies, which are for smaller, quote unquote, small businesses. And under the CARES Act, they transferred or they changed that total indebtedness from 2.7 million to 7.5 million. So certain portfolio companies or PE firms can look into that option as a plan of an in-court restructuring, but it does come with its benefits because of the lesser costs.
Got it. Well, thank you both. That was super insightful and I know helpful for these PE companies. There's more of part of our Game Plan for Recovery series, and thank you so much. We appreciate it.
Thank you.